There have been a lot of updates in the case of Apple going head-to-head against the FBI, who has requested that Apple grant the FBI a backdoor into accessing an iPhone tied to a terroristic case. Well, just this week, a ruling from Judge Orenstein has come out. He is a judge who has ruled in a similar case with the FBI going after Apple to have help accessing an iPhone. And we're going to take a look at that and see how even if you're not in the US, this might affect you. Boop-boop-ba-doop. Full disclaimer, as always, I am a former Apple employee, but all opinions are my own. Now, if you need a primer on this topic and why it is so important, I have a link in the description below to my original video, where I discuss how this may be about more than just one iPhone and could actually be part of a bigger battle of the government going against large tech companies in the battle of national security versus privacy. And as it turns out, I actually have some confirmation for you today that concern was warranted. Now, there are two cases that are being reviewed simultaneously. There's the case that's being reviewed for the iPhone in California that's tied to the San Bernardino shootings. And then there's the case that we're looking at today, which is regarding a different iPhone that the government also wanted to try to gain access to. This case is presided over by Judge James Orenstein, who is a magistrate judge in New York, whereas the California case, which is the case that we've been discussing, is ruled over by Judge Sherry Pym. Now, both judges are magistrate judges at the same level, which means the decision of one judge is not legally binding on the decision of another judge. However, it is likely to influence that decision. And that's what makes this case so important, and that's why we're going to look at it in detail. I'm going to be referring to this case as Judge Orenstein's decision, and we're going to be taking a look at how it might affect Judge Pym's decision in the current highly contentious iPhone case that Apple has been publicizing lately. Now, the case we're looking at today, Orenstein's decision, involves an iPhone 5C, which was running iOS 7, which is not as secure as the phone in the California case, which was running iOS 8. Also, the Orenstein case was about a criminal matter rather than a matter of national security. In this case, it involves a man named Yun Feng, who is accused of trafficking methamphetamine. And in both cases, the government is using the All Writs Act to justify this compulsion. Now, the case with Feng was originally shelved because he pleaded guilty, but it's been brought back into consideration because of the current events with the California phone. We could see here, Feng pleaded guilty to a narcotics conspiracy, and the government's investigation into that conspiracy is ongoing. The underlying search warrant authorizes the government to seize evidence relating to Feng and others, including customers and sources of drugs. Now, bear in mind, this is Judge Orenstein's actual decision that we are looking at. This is a 50-page document. It is available on Pacer for those who want to download it. I believe you do need to pay to access that, so I might make a website down the road where I could host these documents for you, but I will go through as much as I can in this video. Now, Apple pointed out in their response that this is not the first time that the government is compelling them to bypass the security of iPhones. In fact, Apple identified 9 requests filed in federal courts across the country from October 8th, 2015 through February 9th, 2016. In each, Apple has been ordered under the authority of the All Writs Act, or has been told that an order has been requested or entered to help the government bypass the passcode security of a total of 12 devices. In each such case in which Apple has actually received a court order, Apple has objected. Now, this is a concern I addressed in my first video on this topic, which is that in the battle of national security versus personal privacy, Apple might just be a pawn, and it might not just be about the one California iPhone that was tied to a terroristic case, but really this could just be a maneuver by the FBI to compel Apple to assist them in other cases and create tools that, once they exist, can be used against multiple devices. And it appears that not only has Apple justified this concern, but there's one very large smoking gun. Now, this has been cited from multiple sources, but I actually have the audio for you here. Manhattan District Attorney Cyrus Vance has actually said that the government wants to use this tool that Apple would create to allow them access into the iPhone for another 175 iPhones. Here's the audio.
So you're saying this is bigger than just this one case, that this is a problem you run up against all the time?
In fact, Rachel, it's a problem that affects us more than actually, I believe, it affects the federal government. We started tracking the number of iOS 8 devices that we cannot access as a result of Apple's decision in late 2014. And over that year and a half time period, there are now 175 phones that we cannot access out of a universe of 670 phones that our cyber lab has evaluated.
Now, this is huge, and a link to that full interview, which is only about 5 minutes long, is in the description below. I highly encourage you to listen to it. Now, what started out as a case that was positioned to us as one iPhone that the government wanted to access because of how it was tied to the San Bernardino massacre, and because the attackers in that massacre might have ties to ISIS. So this was presented to us as a national security issue for one phone. We're now seeing that this isn't just about one phone. It's about many phones that the government wants access to, and it is trying to compel Apple to bypass consumer security. So this is your personal privacy we're talking about. But the compulsion that they are placing on Apple in particular right now is going to be what is likely considered an undue burden on Apple, who is a private company and not a government-owned entity. As Judge Orenstein mentioned, this matter is therefore one of a dozen pending cases in which the government and Apple disagree as to the court's authority to command Apple to assist the government in defeating the passcode security of devices Apple has manufactured. Now let's take a closer look at how Orenstein interpreted the All Writs Act. This is really at the heart of the matter, since this is what the government is trying to use to justify the compulsion of Apple to bypass security. 1. Issuance of the writ must be in aid of the issuing court's jurisdiction. 2. The type of writ requested must be necessary or appropriate to provide such aid to the issuing court's jurisdiction. And 3. The issuance of the writ must be agreeable to the usages and principles of the law. If an application under the AWA meets all 3 of those requirements, remember, it has to meet all 3, the court may issue the requested writ in the exercise of its discretion, but it is never required to do so. Therefore, even if all 3 requirements are met, the judge does not have to issue an order making Apple assist the FBI. And in fact, the government trying to pursue this option could be considered them trying to legislate from the bench. We have separation of powers with 3 major branches in the government. We've got the executive, the legislative, and the judicial. So executive being the president, legislative being the Senate and the House of Representatives, and judicial being the courts. So rather than trying to go through the legislative branch of passing a law that would give the government access into iPhones and personal devices of citizens, which would likely be considered unconstitutional, they're arguably trying to legislate from the bench by trying to get the courts to rule in their favor and set precedent rather than going through legislation. Now, Judge Orenstein references precedent from a previous court decision, stating that discretionary action should follow 3 additional factors. 1. The closeness of the relationship between the person or entity to whom the proposed writ is directed and the matter over which the court has jurisdiction. 2. The reasonableness of the burden to be imposed on the writ's subject, in this case, Apple. And 3. The necessity of the requested writ to aid the court's jurisdiction, which does replicate the second statutory element despite the overlapping language. Now, this refers to the New York Telephone Company case, which is very interesting. And in brief, back in those ancient days when phones and landlines all had their infrastructure owned by a central telephone company, the government needed to access one particular line using already existing technology. But they needed access into the New York Telephone Company's offices in order to be able to deploy this device. In that case, the New York Telephone Company resisted, but was ordered to assist the government because it didn't place an undue burden on them. However, in Apple's case, where Apple has argued that they would have to create a facility, a very highly secure facility in order to assist the government in bypassing security features of iPhones where they must have physical access to the phone. Apple's not willing to create that tool unless they have control over it in order to prevent its abuse. And this is an incredibly large burden to place on a private company who still has to maintain being competitive with other companies who don't have to maintain that incredibly costly expense. So what is Judge Orenstein's decision? As set forth below, I conclude that in the circumstances of this case, the government's application does not fully satisfy the statute's threshold requirements. The requirements he's referring to are the requirements of the All Writs Act. On screen here for your reference. Although the government easily satisfies the statute's first two elements, the extraordinary relief it seeks cannot be considered agreeable to the usages and principles of law. In arguing to the contrary, the government posits a reading of the latter phrase so expansive, and in particular in such tension with the doctrine of separation of powers, as to cast doubt on the AWA's constitutionality if adopted. Wow, this is extremely strong language challenging the constitutionality of what the government is trying to do, and pointing out the concern that I mentioned earlier that the government is trying to legislate from the bench. What they are doing, according to Judge Orenstein's decision, is inherently in tension with the separation of powers that the U.S. is founded on. But wait, there's more. Moreover, I further conclude that even if the statute does apply, all three discretionary factors weigh against issuance of the requested writ, and that the application should therefore be denied as a matter of discretion, even if it is available as a matter of law. And here are those three factors again on screen for your reference. Now, there is so much going on with this 50-page decision that I could discuss it for hours, but let's take a look at the bigger picture. This decision came from a magistrate judge who is a peer, that is to say, on the same level as the magistrate judge in California, who is going to be ruling on the California iPhone case, the one that's connected with the San Bernardino attack. Judge Orenstein's case has already been appealed and being brought before an Article 3 judge, which is the level above him. But his ruling has serious implications. Although this case is taking place in the United States, Apple is a global company, and once the software to bypass iPhone security exists, virtually any government entity will be able to compel Apple to assist them in bypassing iPhone security. Think China. An overwhelming amount of Apple's manufacturing is done in China, and if Apple weren't to assist the Chinese government could hit Apple where it really hurts, right in the manufacturing. Add to the fact that China is one of the leaders in cyber warfare. So once the Chinese government has access to a tool like this, what do you think the future of that tool might be? Do you think it might get used in a way that we don't want? This is an incredibly important situation, so as long as it keeps developing and you want to keep hearing about it, I will keep covering it for you. Now you know the whole story. Let me know your thoughts on the topic in the comments below. As always, comments are not moderated so that they stay reflective of popular opinion. If you found this insightful, be sure to share it, and don't forget to subscribe for more stories that are worth a second look. You should watch this video too right now. Here. In the greater battle of government security versus personal privacy. Boop, boop, ba-doo.